Assalamualaikum and hi everyone. Our group will be presenting about question number 10 regarding our last assessment for the Intro to Contra and Tort law subject. This is the scenario given to us. This is Tarakija. Tarakija was injured when renovating a ballroom in an abandoned bungalow. Her parents sued the town council for damages for the negligence of the breach of duty of care since they need to pay a high-cost hospital bill due to the medical treatment. In the recent scenario, the councils from both parties may argue on the liability of the town council for causing the accident. At the first glance, it may seem like the town council is liable for not demolishing the house, but the accident will more likely not injure the teenager if she was not trespassing the abandoned area and renovate the dreadful-looking house. The issue for this scenario is whether the town council can be held liable for negligence for breach of duty which had injured the claimant due to the fallen huge chandelier. In order to prove who should be held responsible, we should look into the elements of negligence. First, duty of care. In this scenario, it was affirmed that it was the negligence of the omission by the town council for not acting sooner in demolishing the bungalow. However, in English law, negligence due to omission rarely happens. It is because the duties imposed by laws to others generally only cover the act of not causing troubles for other people. Even so, the English courts have made three exceptions to claim negligence under omission. First, control exercised by the defendant. Second, assumption of responsibility. Third, creation of risk. The most appropriate approach to take for this claim is the third, the creation of the risk. The defendant's failure to demolish the bungalow, even though the condition of the house is concerning, has created the risk, and if the defendant has demolished the house a long time ago, the teenager will not refurbish the house, thus the accident will not take place. In determining whether there was a duty of care, we need to use the Caparo test. As its name suggested, the test was established in Caparo Industries and Dickman. In the long history of the law of negligence, three tests had taken place before today's test. The fourth established. The three stages of questions in the Caparo test: first, was the damage reasonably foreseeable? Second, was there a relationship of proximity between defendant and plaintiff? Third, is it just, fair and reasonable to impose a duty in this situation? In the given scenario, we do not think that it is needed for us to use the three stages questions to find whether there was a duty of care because there were already precedents concerning the facts. The precedents that we found appropriate to use are Jolie and Sutton London Borough Council and Huggins and Lord Advocate. In Jolie, two boys found a boot in a yard of a flat which owned by the defendant. The two boys started to repair the boats with some woods and nails and glued them to sail at Cornwall. The incident had caused one of the boys to get a severe back injury and became paraplegic. The House of Lords held the defendant was liable due to the injury causing following action of repairing the boat was foreseeable, and the defendant thus owed duty if care towards the plaintiff. Second, breach of duty. Before the plaintiff has to prove the breach of duty, the court needs to come out with a standard of care to impose towards the defendant. In deciding what should be done in the circumstances, the court will consider 6 things and balance them with each other. First, special characteristics of the defendant. Second, special characteristics of the plaintiff. Third, the size of the risk. Fourth, how far it was practical to protect from the risk. Fifth, the common practice in the relevant field. 6. Benefits to society by taking the risk. We think that a normal reasonable test is already sufficient for this case. If we use the question, what a reasonable man would do if a house was under their supervision to demolish it, but they are not and they have the duty of care to not let a person getting injured by the house, we were of the view that he is in breach of duty of care as they supposedly to demolish the house in the first place. The duty of care has been established, and it is a matter of fact to prove the breach of the said duty by the plaintiff and let the court decide based on the balance of probabilities. In Arab Finance, Berhad and Stephen Fua, Cheng Dun and others, the court held that the fifth and seventh defendants, landowners of the land near a collapsed apartment due to heavy downpour, were liable for negligence. In the instant case, the abandoned bungalow is under supervision and jurisdiction of the town council. It shall be noted they were not liable in the circumstances of this case. Moreover, we need to bear in mind that the breach of duty is the omission of the defendant by not demolish the house when it was already in a dreadful condition, not the dreadful condition itself.
And now for the third element of negligence, which is damage. For a claim of negligence to be successful, the damage needs to be caused by the defendant's commission or omission. If there was a damage, but it cannot be proved it was the fault by the tortfeasor, the claim would be failed. In Fowler and Learning, Diplock J stated that onus of proof is upon the plaintiff or the claimant for the allegation of negligence or unintentional torts. In the present case, it was clearly stated in material facts. The claimant has suffered an injury, which are spinal cord problems and head injuries after getting hit by a chandelier. In the worst case scenario, the injuries the plaintiff suffers will lead to stroke. However, the intended allegation to be made by the plaintiff is solely for medical expenses. This shows that the great damage has fallen upon the plaintiff. And the last element of negligence, causation. To succeed in pleading for negligence, not unlike the elements of damage we discussed before, it must be proved by the claimant that the breach of said duty is the reason of the said damage happened. The principles to establish causation for this instant case are the but-for test and remoteness of damage. The but-for test. If the test were applied, the question would be, would Tarakija suffer damage but for the town council's omission to not demolish the house when the house is in terrible condition? As in material facts of this case, the occurrence happened due to the condition of the house, and it is possible to say the accident happened because of renovation or other reason, as it does not mention in the facts given, unless the defendant can prove so. Next, remoteness of the damage. In the present case, the remoteness test has already been used as we extend the principle in Jolly and Sutton London Borough Council. The laws of the case decide to use the statement from the judgment of the first instance court, Mr. Geoffrey Bryce, Queen's Counsel. To extend the remoteness of damage, the risk that should be considered in court is a child would meddle with the boat and the risk of some physical injury. Hence, we suggest the reasonable possibility in the present case should be something like a risk of one to intervene with the house and resulting in some injuries caused by the house. We intentionally changed the word child to one due to a reason. In Jolly, the case is concerned with an abandoned boat which is impossible for an adult to meddle with it, but possible for a child to do so. As for this case, anyone can enter the premise to meddle with it, instead of being young or old, man or woman, normal or drug addicts. Now, let's move on to remedy for this scenario. In this case, As for the result of the negligence, the injured party shall claim for damages for the injury done by the defendant. Furthermore, damages can be awarded to the claimant as referring to the precedent in Jolly and Sutton London Borough Council and Hughes and Lord Advocate. For both cases, the plaintiff appeals were allowed by the court. Finally, we arrive at the last part of this case, which is possible defense by the defendant. The defendant must prove to not be liable for the wrong act as claimed by the plaintiff. In this case scenario, the defendant must prove to not be liable on negligence or not being the only party liable for the negligence. Thus, the defendant in this situation shall prove either voluntary non-fit injuria or contributory negligence to win the case. As for the first possible defense by the defendant, which is voluntary non-fit injuria. Based on the fact given, there was a warning sign placed at the front yard of the house. It was already mentioned, the house already in a dreadful condition, with the floors being creaky, the ceiling was falling apart, the walls were cracking, and the windows were smashed. All these facts already tell us that the plaintiff should know the danger that might happen when entering the house. Despite acknowledging the danger, the plaintiff trespassed the premise to refurbish the place. We can boldly say that the plaintiff put the danger onto herself. In Reeves and Commissioner of Police of the Metropolis, the judges said, in any event, the defense is inapplicable to a case which involves a deliberate act of self-deception. Thus, the defense is founded on good sense and justice, that one who has invited or assented to an act being done towards him cannot complain of it as a wrong when he suffers from it. The concept of such an act being done towards the plaintiff connotes the action of another person, which is the defendant, and not the plaintiff's own action on himself. The essence of the voluntary principle is that a person freely, voluntarily, and with knowledge of a risk accepted it as something for which he and not the defendant took responsibility. Referring to the judgment of the case, the defendant might win the case because of the knowledge of the dreadful condition of the bungalow by the plaintiff and the project that may handled by the defendant at the same place. Moreover, the claimant herself voluntarily renovated the bungalow, which is in the essence of the said principle. As for the second and the last possible defense by the defendant, which is contributory negligence, the basis of the rule is the party who alleged the claim will also be held partly liable for not taking good care of oneself. In another word, it can be said that the plaintiff itself was contributed to the damage caused by the negligence of the defendant. The effect of this defense will reduce the amount of damages that should be awarded to the plaintiff. In Malaysia, for defense in contributory negligence, we refer to Section 12 of Civil Law Act 1956, where any person suffers damage as the result partly of his own fault and partly of the fault of any other person, a claim in respect of the damage shall not be defeated by the reason of the fault of the person suffering the damage, but the damages recoverable in respect. This means that for this defense, the defendant will not argue for being not liable, but the liability is not for him to bear alone. In this instant case, some may argue to what extent should be used for an infant in determining reasonable care for such defense. In cases like Muhammad Zuhairi Abdul Ghaffar and Kwek Chen Ki, Jab Singh and Tung Fong Omnibus Co Ltd and Tiu Siu Goh and Tai Tian Su. For plaintiff for these three cases is an infant or not yet reached legal age, but the plaintiff still were held liable for contributory negligence. In short, based on the authority from the cases, a normal reasonable self-care test should be imposed on the plaintiff, as she was not having any distinguishing features from others. As she was near of the age of majority, a loss reasonable of care should not be an option. Moreover, the quantum for this defense, the court will determine the amount of the plaintiff should be held liable solely based on the balance of probabilities. In a nutshell, based on the fact of the case given, there was already sufficient proof for plaintiff to sue the tortfeasor under the law of negligence. The plaintiff will ask for damages to pay medical expenses for treatment, and the defendant may argue either for absolute denial to the liability, which is voluntary non-fit injuria, or part liable of the occurrence, which is contributory negligence. The case is worth to be tried by the court for further clarifications of the fact and law.
That's all from us. Thank you for watching, and till we meet again.